Hi guys, the former Attorney General of Federation has come out to expose the shocking secret that will make Bola Ahmed Tinubu not to become Nigerian president because of his dual citizenship and not winning the 25% in Abuja. Guys, watch this video and you will hear many more secrets that he revealed, and don't forget to share your thought with us.
I want you to talk about the pick and choose that we see in public dispensation of justice. The fact that if cases concern people that don't wield power, it is fast-tracked and accelerated. But if it concerns people that wield power, what you just said now could apply. The fact that when you even put up the case and it goes through trial can be elongated and the likes and all of that. And also, I want you to also make a clarification and distinction between public morality and the ecosystem we live in Nigeria. The fact that a top candidate that eventually became president-elect didn't deem it fit to make a declaration of the fact that he hitherto had another passport, which is not a big deal, which is not against the law, in his form. That's a case of public morality. I know, yes, that might not hold water in the logicality of the law, but that's a case of public morality and public perception, which you cannot discount from societal ecosystem, because you said just now that court cases also have a look and feel of societal factors.
Well, thank you very much. Certainly, the issue of morality comes in. I will not deny that fact. It's a very big burden on society.
Morality is not law.
To see we leaders appear to violate the law. But you could see there's a presumption in law of a person is adjudged not to be guilty until he's proven. If you say that, still until trial commences and he's convicted. I have agreed with you on the issue of the burden of morality. But I also have shown you the constitutional provision that we have to take the morality, if we have to take the morality to enforce into law, we must follow this. And the thing is that we arraign the person to court, the person take his plea, and if he says he is now guilty, then we have to bring evidence. Trial will go normally, and there will be conviction. It is expected. Speedy trial is the expectation of the whole country. But I pointed out the shortage of judges, the condition in which they live. If you go to the federal high court now, or state high court, perjury is an offense that ought to be prosecuted by the police because of the recent decision of the Supreme Court. It's a state offense. Of course, that means the perjury was committed within the area of Federal Capital Territory, so it has to go to the state high court. And you go to one of the courts, you see courts list 29 cases. And then cases are called based on seniority. Sometimes it's not the fault of the prosecutor. The prosecutor will be a young lawyer. He goes there with the facts, ready to prosecute. Senior counsels come in, call the case after order, because that is a procedure. If the most senior advocate will call his case, if he has 20 cases, he will finish his cases before any other person. By the time this is done, you will discover that time has lapsed, adjournment will be granted. This is occurrence as a result of inadequate staffing of the judiciary. Because the manpower, judges ought not to have more than 5 cases on the court list, but you could see 29 cases. So such adjournments derail justice. And these are some of the things most of us have been advocating. Increase the number of judges for service delivery. A judge should not have more than 5 cases. Perception is there. You cannot doubt about that. Perception is there. And that is the thing that the public is complaining in everything. Mind you, when I came here on your channel before, I said something which the public has been yearning. And I say this is the time the judiciary and everybody involved in administration should look at it. Take, for instance, in the case of electoral matters. Our attitude has been to scrutinize the outcome of the result. This person scored this number. This person scored this number. And therefore, infractions that occurs are targeted on the result, who had the majority. But the main corruption that occurs in the electoral process is refusal to follow the procedure that leads to that result. And that is why at that time, that is what the public is yearning. Nobody will complain about an election if the procedure leading to those results that produce the majority result, which became the winner, and the procedure is followed. Nobody will complain. If you see all the complaint has been that the procedure that's supposed to be done like this is not done. All the elections you have in the cases, the complaint may not necessarily be the overall result. But when we go to court, the target is to prove whether this result is correct or it is not, or this person scored more, forgetting that the main corruption is within the foundation which those results occurred. This is why it goes to the perception you are talking about. That is the perception that things should be done right. In criminal trial, the perception is that everybody should be equal within the law. And it...
Yeah, I just wanted to intervene.
Sorry, sir?
I wanted to intervene at this point. You brought up the issue of your last conversation with Arise News, which became controversial because you had cause to say you were misinterpreted. And I just want you to give us the opportunity for you to clarify your position with regard to 25%, whether you need it in 36 states
and
the federal capital. No, just a moment, sir. Just a moment. You know, I just want you to offer us very strong clarification. We have tried to, state what you said and to correct it. But you are here, so you have a chance. As for the issue about morality, well, with due respect, as you know, morality is not law. And so that's why the courts are always at variance with public perception, because the courts don't deal with morality. They deal with the technical details. Over to you.
Thank you. I never even in any way said morality is law. My previous interview with you also, I told you morality is not law. And I think we are all talking the same thing. Come to my interview. First, I never said amateur ought not to be. You asked me whether there were going to be problems. And I say, yes, there will be problems. And already there are problems. Once a petition is filed, it's a problem. It's a legal problem that has to be resolved by the parties. And I came to the issue of construction of and in between the issue of federal capital, the and there. And I laid the foundation and I said, look, directly in the interpretation of that particular section, which had in between the long sentence and the shorter sentence, has not been done directly. But it has been done in similar other cases. For instance, the issue of corrupt practices and non-compliance has been interpreted. And the interpretation of that and which joined corrupt practices and non-compliance was that it ought to be conjunctive. So that and has been interpreted. If you don't take that interpretation and fit into what is specified in the Constitution, we to third of the Federation and federal capital, the law, if you take that interpretation, which the Supreme Court gave in 2006, to that and which joins corrupt practices and non-compliance and held to be conjunctively, that may be possible in case of that interpretation of the Constitution, because the and has joined being 2/3 of the federation with federal capital, and you cannot do disjunctively. If you do disjunctively, it will lead to absurdity. But if you construct it conjunctively, it will make a meaning. That was what I said. And I'm still saying it. I've not changed that. I say, going to me, and my personal opinion, says that and in corrupt practices and non-compliance in the Electoral Act of 2000, which was interpreted in 2000, use that and to be conjunctive to make a meaning of the issue of corrupt practices and non-compliance. That means corrupt practices is at the same, and non-compliance are interpreted to be conjunctive. They follow together.
So I get your interpretation.
So
the difference between...
And now, if you see, Supreme Court has not yet made a definite pronouncement on that and in between that section of 2/3 and 2/3 of the federation and federal capital. Supreme Court or none of the courts have made a definite pronouncement on that. And if they have not made, I don't see how they will not follow the decision they gave that and in non-compliance, in corrupt practice and non-compliance, it should be conjunctively.
Okay.
But maybe they can say it's disjunctive when it's applicable to the Constitution.
Okay.
Apart from that, there are also other rules of interpretation, which I don't know which one. And I said also that Supreme Court has a right not to follow its own previous decision. They can deviate it. The issue is there going to be a problem? I said, there's a problem. And now with me and Arise here, there's a problem because various people have filed a petition. That is the problem. There's another question I was asked, whether it's non-transmission or result will be a problem. I say it's a problem because INEC rules have constitutional flavor. So if you make rules, you ought. And the Supreme Court decision that says it was a case of CPCs, so Supreme Court's INEC officials have a duty. They are duty bound to obey their own guidelines. And if they do not obey the guidelines, it's a violation of the electoral and the Constitution on the grounds of fair election. That's what I say.
Okay, sir, I get your point.
Thank you for giving that opportunity.
Yeah, sir, I get your point about what is disjunctive, what is conjunctive, and the rules of interpretation. I understand all of that. But for clarity purposes, are you saying categorically that Bola Ahmed Tinubu does not need to score 25% of the votes in the Federal Capital Territory? I guess that's how the ordinary person will understand it.
And I'm not saying that. And I'm saying that an opportunity has come again for the Federal Court for the court to give a direct interpretation of that and, which is in between 2/3 of the federation and federal capital. If they say it is disjunctively, it means he does not. But if he say it's conjunctively, then the meaning will be otherwise. But apart from these two rules, there's also mischief rules which the court can override what I'm saying and try to look at what is the purpose that is going to happen, what is the mischief. And I also mentioned to you that Supreme Court is a court of policy and law too, so they may look at other things differently. This is the position. But that section has never, interpretation of that section has not been the and in between that 2/3 of the federation and federal capital has that and in between those two, that sentence has never been interpreted. And I feel the time has come. We cannot gloss over the provisions of the Constitution.
Yes.
It is most important for us, any issue that comes out of the Constitution is to be interpreted based on the literal constructions of the wordings of the Constitution to lay a precedent.
Well, all eyes on the Supreme Court now. But Mr. Aondoakaa, that leads me to my next question with regards to the role of the judiciary in election matters. I'm glad you talked about the procedure or the process and the reason why we have had so many uproars or challenges post-elections, because when the process isn't clear or isn't fair or isn't deemed to be fair, then you would have a number of people challenge the result of that process. But I want you to focus on the role of the judiciary. There's a trust deficit in the judiciary, especially amongst Nigerians and even politicians who are petitioning the courts. How do you think we can change what might be a perception or the truth. How can we begin to reform, change, and ensure that we restore that institution of the judiciary?
Thank you. Maybe the emphasis has been more on us lawyers that present our petitions. And the judges cannot go otherwise than what is requested of them to interpret. In most times we go to court,